If you think you are safe because you have a permit, this new law in Virginia just changed the game. On May 14th, 2026, Governor Abigail Spanberger signed Senate Bill 749 and House Bill 217 into law. It takes effect on July 1st, 2026, 11 days from now. And what it does is ban the importation, sale, manufacture, purchase, and transfer of specific semi-automatic firearms that Virginia defines as assault firearms, as well as any magazine capable of holding more than 15 rounds. This is not a rumor. It is not a proposed bill. It is signed law with a hard, effective date. And if you are a Virginia gun owner, a Virginia dealer, or anyone who's been thinking about buying an AR-15 and lives in the Commonwealth, the next 11 days may be the most important gun-related decision window of your life. Subscribe right now, because this situation is changing every single day, and I am covering every development the moment it happens. Let me walk you through exactly what the source legislation says and what it means in plain language. The law bans 5 specific actions: importation, sale, manufacture, purchase, or transfer. That covers the entire chain of commerce. It is not just retailers. It covers private party transfers too. If you try to sell your friend a magazine that holds more than 15 rounds after July 1st, that is a violation. If you try to buy one, that is a violation. Both sides of the transaction are covered. The second thing you need to understand is how Virginia defines an assault firearm, because here is the hidden trap that is going to catch gun owners off guard. Virginia does not ban guns by name. It does not publish a list of specific makes and models. Instead, it bans semi-automatic firearms that have a detachable magazine combined with any one of a list of prohibited features. One feature. That is all it takes. This is what lawyers and policy analysts call a feature-based ban, and it is intentionally broad. So what features trigger the ban on a semi-automatic centerfire rifle? A pistol grip that protrudes below the action. That covers the standard grip on virtually every AR-15 in existence. A folding or telescoping stock. That covers the mil-spec collapsible stock found on most modern sporting rifles. A flash suppressor. Standard equipment from the factory on most AR-15s. A threaded barrel, even if the flash suppressor is removed because the threading itself counts. A forward pistol grip attached to the handguard. And critically, a barrel shroud, which the law describes as a device that encircles or is attached to the barrel and permits the shooter to hold the barrel area without burning their hand. Gun rights attorneys in Virginia have flagged that standard M-lock and Picatinny rail handguards almost certainly meet this definition of a barrel shroud. That means an AR-15 configured with modern rail furniture, which describes the majority of AR-15s sold in the last decade, is captured by this ban even if the owner has removed every other prohibited feature. This is the detail that is catching both dealers and consumers completely off guard. The 15-round magazine ban is a separate provision from the assault firearm definition. The two operate independently. A magazine ban violation does not require that the firearm itself be an assault firearm. If you have a standard Glock 17 magazine which holds 17 rounds, that magazine is banned under SB 749 regardless of what firearm it feeds. Glock 19 magazines, which hold 15 rounds, are not banned because the threshold is more than 15. But anything above 15, including the factory standard magazines for many of the most popular handguns and rifles in America, is prohibited from sale, purchase, transfer, import, or manufacture in Virginia after July 1st. Now, let me talk about the grandfather clause. Because the grandfather clause is real, it is meaningful, and it is also much more limited than most people think. According to the source legislation, the grandfather clause protects firearms and magazines that were lawfully purchased before July 1st, 2026. If you own an AR-15 today, you can keep it after July 1st. You do not have to surrender it. You do not have to modify it. You do not have to register it with the state. Your continued possession is protected. But here is what the grandfather clause does not protect, and this is where the real restriction bites. The grandfather clause protects possession. It does not authorize transfer. After July 1st, you cannot sell your grandfathered AR-15 to a fellow Virginia civilian. You cannot give it as a gift. You cannot trade it for another firearm. And when you pass away, your adult children in Virginia may not be able to legally take possession of it through your estate. The market for these firearms is not just restricted, it is permanently frozen. Every grandfathered firearm becomes a one-time, one-owner item that disappears from the civilian market in Virginia the moment it changes hands or the owner dies. Think about what that means in practical terms over a generation. The inventory of grandfathered assault firearms in private Virginia hands will only ever shrink. It will never grow. Theft, loss, damage, and death will reduce the number year by year, and no new firearms in this category will ever replace them in the hands of Virginia civilians. That is the long-term strategic goal of this legislation. Not confiscation, which would be politically impossible, just permanent attrition. Hey, 73% of people watching right now are not subscribed. If you are a Virginia gun owner and you need to know the moment any court issues an injunction that pauses this law, this channel is your fastest source. Subscribe right now. Let me now tell you about the lawsuits, because the lawsuits are the reason this law might never actually take effect. Multiple organizations filed legal challenges within minutes and hours of Governor Spanberger's signature. In the federal courts, the National Rifle Association, the Firearms Policy Coalition, and the Second Amendment Foundation jointly filed a case called McDonald v. Katz in the Eastern District of Virginia, the court system known as the Rocket Docket because of how quickly it resolves cases. In the state courts, the National Shooting Sports Foundation backed a case called Black v. Hook in Fauquier County Circuit Court with an emergency injunction request. Gun Owners of America and the Virginia Citizens Defense League filed a case called Crump v. Katz in Lancaster County Circuit Court, also with an emergency injunction request. The NRA and Virginia Shooting Sports Association filed Santola v. Katz in Washington County. And former Virginia Attorney General Kenneth Cuccinelli filed two additional state cases, Curtis v. Katz and Holloway v. Katz in Spotsylvania County, arguing that the ban violates the militia clause of the Virginia Constitution. Here is where the litigation stands as of today, June 20th, 2026. Yesterday, June 19th, 2026, a Spotsylvania County Circuit Court judge heard argument in Curtis v. Katz, the Cuccinelli militia case, and denied the preliminary injunction. The judge ruled against the gun owners. His reasoning was troubling to Second Amendment attorneys, not just because of the outcome, but because of how he got there. He applied interest balancing, weighing public safety interests against the burden on gun rights. The problem is that the United States Supreme Court, in its 2022 Bruin decision, explicitly abolished interest balancing as the test for Second Amendment cases. Courts are supposed to look at history and tradition, not weigh competing interests. Gun rights attorneys across the country are describing the Spotsylvania ruling as a textbook Bruin violation by the trial court. Cuccinelli is now evaluating whether to appeal. He has 15 days from the ruling to file a notice of appeal. The other cases are still pending. Emergency injunction hearings have been requested in Black v. Hook and Crump v. Katz for hearings before July 1st. No other court has yet ruled. One granted injunction in any one of these cases would pause the law statewide, and the source legislation, Senate Bill 749, contains no emergency clause, which means the standard Virginia effective date of July 1st applies. There is still a window, but the window is closing. There is also a remarkable and unusual development in the Spotsylvania litigation worth mentioning. Ryan Mahaffey, the Commonwealth's attorney for Spotsylvania County, is technically listed as a defendant in the Curtis v. Katz case because he is the local prosecutor. But Mahaffey filed a legal brief arguing that the plaintiffs should win and the injunction should be granted, a defendant arguing against his own side in open court. He has also publicly stated he will not enforce Senate Bill 749 if it takes effect. He is not alone. Multiple Virginia Commonwealth's attorneys across different jurisdictions have made the same public declaration. They will not prosecute violations of this law. This creates a genuinely unusual patchwork enforcement landscape. In some Virginia counties, the law may exist on the books but go unenforced at the prosecutorial level. In other counties, prosecutors may actively enforce it. Virginia State Police can still make arrests regardless of local prosecutorial policy, but the practical risk of criminal consequences varies dramatically depending on where in Virginia you are. Let me now give you the action steps every Virginia gun owner needs to take right now, starting today. The most urgent action is this. If you have been considering purchasing an AR-15 or any other modern sporting rifle, or any pistol with features that could be captured by the feature-based definition, or any magazine holding more than 15 rounds, The deadline to make that purchase and complete that transfer is June 30th, 2026, one day before the law takes effect. After July 1st, absent a court order pausing the law, those transactions become criminal violations. You have 11 days. If you want to be grandfathered, you must act now. The second step is to document your current collection. If you already own firearms or magazines that will be covered by SB 749, create a clear written record today. Note the date you acquired each item. Keep any receipts, ATF transfer records, or other documentation that demonstrates you lawfully owned these items before July 1st, 2026. The grandfather clause requires that items were lawfully purchased before the effective date. Documentation proving that purchase date is your protection if your possession is ever questioned. The third step is to watch the courts. The situation is changing daily. An injunction granted before July 1st in Black versus Hook, Crump versus Katz, or Santola versus Katz would pause the law immediately and change everything. Follow NRAILA, the Firearms Policy Coalition, and the Virginia Citizens Defense League for real-time updates. And subscribe to this channel because I will have coverage of every court development within hours of it happening. The fourth step, if you are a licensed firearms dealer or FFL in Virginia, is to get legal counsel today. Not next week, today. You need a compliance review of your current inventory against the feature-based definition in SB 749. You need a clear legal opinion on which items must come off the sales floor before July 1st and what you must do with existing orders. Dealers who complete covered transactions after July 1st face the same criminal exposure as individual buyers and sellers. The compliance window is 11 days. Act now. The fifth step is to understand the big picture of why this fight matters beyond Virginia's borders. The legal team behind McDonald versus Katz, the federal lawsuit in the Eastern District of Virginia, has structured that case as a deliberate pathway to the United States Supreme Court. They know the Fourth Circuit Court of Appeals has precedents upholding assault weapons bans in Maryland. They know they will likely lose at the district court and potentially at the Fourth Circuit level. That is part of the strategy. They are building a clean, unburdened federal record specifically designed to petition the Supreme Court and force it to answer the question it has been avoiding since Bruin. Can states ban the most commonly owned category of rifle in America? That question will be answered in the Supreme Court. Virginia is the case that may put it there. If the Supreme Court takes a Virginia assault weapons ban case and strikes it down, it does not just affect Virginia. It strikes down every assault weapons ban in the country. California, Maryland, New York, New Jersey, Connecticut, Massachusetts, Illinois, Hawaii, Colorado, Rhode Island. All of them would fall in a single ruling. That is what is ultimately at stake here. Governor Spanberger signed Senate Bill 749, but the legal fight she triggered may end up deciding the future of the Second Amendment for all 50 states. Subscribe right now because the court decisions in the next 11 days could determine whether July 1st means anything at all for Virginia gun owners, and I will have every ruling covered the moment it lands. This is educational content only, not legal advice. For your specific situation, especially if you are a dealer or have questions about specific firearms you own or are planning to purchase, consult a qualified firearms attorney licensed in Virginia before July 1st. The law is clear, the deadline is real, and the time to act is now.